Hi folks, and welcome to the IP Flow Show. I'm Ana Sofia Walsh. My guest today is Jed Ferdinand, founding attorney of Ferdinand IP. Welcome to the show, Jed.
Thanks so much for having me. It's a pleasure to be here.
Great. So our topic for today is Brexit and trademarks. As we all know, the UK voted in large majority to leave the European Union. The current status is that the UK is still a member of the European Union until Article 50 is triggered. But assuming it is triggered post-negotiations, we're going to discuss a bit how that will affect intellectual property and, most importantly, trademarks. Would you like to kick us off? For instance, how is this going to affect currently registered trademarks in the EU?
Sure.
Will they need to be re-registered or?
Sure, so that's an excellent question. And the good news is, as you said, until Article 50 is triggered, nothing's going to happen. So we'll have status quo. And then for 2 years, we can expect a period of negotiations, both on general commercial laws, of which there are going to be many that will need to be reconfigured. And then, of course, within that are going to be the intellectual property laws. So let me just give a brief bit of background on the way trademarks are handled in the European community right now. So right now there's two different ways of filing trademarks. The more traditional way called national trademark applications, and those are on a country-by-country basis. But for about the last 20 years or so, you've been able to file a trademark that covers the entire European Union in a single application. This is called a community trademark, or now it's called the European trademark. That's the problem with the most recent Brexit vote. What's going to happen to that European community trademark? And I can tell you, so I work with colleagues in Europe. I'm part of a firm with offices in the UK, Germany, and France. And there's a lot of confusion right now because this has never happened before. The most analogous example in history is probably the breakup of the Soviet Union. When that happened, you had, I think, 15 or so different states, but they were starting from scratch, right? They had to create their own legal systems and create their own IP systems. Now you have the UK, of course, with a very developed IP protection system. I'd love to be able to say that the easiest solution will be that with rights you have now that cover the entire European Union, as soon as the breakup happens, that you'll be able to essentially extend that protection to the UK with no disruption. That would be an ideal scenario. The problem is, how's that going to work? You just automatically get protection extended from the original filing date? Will there be any additional fees involved? So I can tell you that the day this happened, we contacted a lot of our larger clients. And these are companies, with large IP budgets who can afford additional trademark protection. And we said to them, no one knows what's going to happen in the next 2 years, but for an abundance of caution, we would highly recommend that you file new national trademark applications in the UK just to be safe. And I should say the reason to do that is the European Union, the UK, these are all what we call right to register trademark jurisdictions, meaning if you don't have registered rights, you don't have any rights at all. So it's really critical to make sure as a brand owner that you have registrations in place. And the safest way to do that now is to have them on a national basis in the UK.
I mean, even in the future, it all will also depend whether the UK itself will want to give up sovereignty of its IP. Because they might not want to maintain the status quo and have the trademarks within the wider EU system. If they've voted to leave the EU, they might just want to vote to leave all the different political systems because they're not really into federalism.
Right. I think that that's exactly going to happen. And so I think you're going to have two different systems. You're going to have a UK system, and then you're going to have a system for the rest of the EU. And the problem in the future then will be, so we've talked up till this point about existing registrations. What about all the new filings that are going to happen? So in the future, I think what's going to happen for the new filings, you're going to have to do it twice. You're going to have to file in the UK, and then you're going to have to file in the EU. So what does that mean? It means it's a lot more expensive. And so you don't get the benefit of the single registration anymore.
No, everything is going to become more costly if this article is triggered. Because already, if you want to file international trademarks, you have to go through a whole different system. So it's a bit of a headache for businesses nowadays.
Right, the headache for businesses. The way I thought about this, business owners hate disruption, right? They like certainty, and I hate to be a crass commercialist, but lawyers, we love disruption because we benefit from the uncertainty because it's our job to analyze this and provide advice. And then this is something that I commented on even before in an article, even before the Brexit happened. This will be a benefit to UK IP lawyers because we expect that there will be quite a few more filings of trademark applications, design applications. There's going to be a lot more work for the UK IP lawyers, for sure.
That's true. It's not just the European Union law guys. It's going to be the IP lawyers too.
Yes.
So how do you think this is going to affect other aspects of trademark, like lawsuits, for instance?
So that's another very good question, which is the UK now follows the EU law. We expect that they're going to separate from that as well. They're going to have their own developed body of law. We don't know what that's going to look like. So it will make the enforceability of judgments more challenging. You're no longer going to be able to get a single judgment that's going to impact the entire EU anymore. Now, like I said, you used to be able to get one trademark. Now you may have to get 2 trademarks and 2 lawsuits, one for the EU and one for the UK. So again, that's not good for businesses. It's just more expensive. And there's lots of other areas this impacts. So we do a lot of trademark licensing agreements. And until now, you've always defined the territory as the entire EU. Now you're going to have to define that territory as UK and EU. So the UK is going to become a standalone for a lot of agreements.
What is the current situation as to how Norway and the Swiss stand? Because they also have a lot of the similar EU laws that they've signed up to.
They do.
But their IP is quite different also.
Right, so they've never been a part of it by choice. And so they've always been separately protected. So that's actually an excellent analogy because how they've been dealt with, which they're really islands unto themselves, right? You have to do separate filings, separate lawsuits in those territories. That's what's going to become of the UK. And the interesting thing is what will happen from the transition period to the extension of current protection, whereas in Norway, they never had it. So they've always operated on their own.
Yeah, you would expect that there's going to be, even if they could draft the legislation and everything, that there has to be some kind of transitional period where protection is guaranteed for existing trademark owners.
I think so, because if you don't, what's going to happen is like what's been happening in China for the last 5 years, which are, rampant trademark piracy and squatting, where people run to the trademark office, try to file something quickly, and try to gain rights over the legitimate user, and that's a nightmare.
Oh, absolutely. It'll be interesting to see how they craft the legislation because, correct me if I'm wrong, I think Norway and Switzerland are both civil law countries, and maybe they'll borrow some inspiration from the US. Who knows?
Maybe. Yeah, they are. And that is different with England being common law. So. Yeah.
It'll be interesting. I'm just interested to see how it's all going to develop because if this whole situation does actually come to light, how that was going to affect, the position of Scotland and whether they're going to go in or out and how all that IP struggle there is going to happen.
Right. So, it's funny. There's so many bigger issues that need to be determined. What's going to happen with Scotland? What's going to happen with the City of London? From what I understand, they would prefer to remain and have the benefits. So could Scotland become its own independent nation now that would develop its own independent IP? Because right now they're subsumed within the UK. So that's another fascinating area. I mean, I have to say, from an intellectual standpoint, this is really interesting. From a business standpoint, for clients' sake, it's really challenging, yes. And I know that there's so much more going on in terms of deals that are not being done, investments not being made. Again, people don't like uncertainty, and it makes them reluctant to want to invest in new new projects.
As an Irish person, this is great for the economy in Ireland. It's just going up and up because a lot of businesses are just picking up and moving to Dublin and joining the Facebooks and of this world, which is great.
Yes, they will benefit greatly. As an aside, there's a big political campaign going on here, and all we hear about is how well Ireland's doing, and why aren't we doing as well as Ireland? So.
What can you do, Well, we had our ups and downs, The last 10 years haven't exactly been good to us. Well, thank you so much for speaking with us, Jed. It's been lovely to have you on the show.
My pleasure. It was really enjoyable. Thank you for having me.
Absolutely. And that was Jed Ferdinand of Ferdinand IP. If you'd like to check out more of the stuff we're working on, please log on to our website, mimesislaw.com/IPflow. Follow us on Twitter and Facebook and subscribe to the channel. That was the IP Flow Show, and I'm Ana Sofia Walsh. Thank you for watching, and see you next time. A lot more thought into your brand because of these petty lawsuits.
Well, I think, yes, I think there does seem to be an emphasis on awareness of the overall image for whatever you're doing. And that's good. I just think that the lawyers involved in this process, that we can do better in terms of kind of setting people in the right direction or setting people on the right track, because we still, amongst ourselves, use a lot of the language of property. We refer to this as, trademarks as